Public interest litigation, now we can say that it's ages that has evolved with time. And every citizen, whatever he has the fascination toward law, would know that public interest litigations has changed the dynamics within India and large perspectives of law. And today's topic is public interest litigation, evolution and law by Gopi Karunakaran, an advocate of Karnataka High Court. It has been a pleasure connecting with him through Ma'am Sushila, a senior advocate, who strongly recommended her, and whatever connections we had and interaction before going live to this session. I found that Mr. Gopi is well versed with the law, and I'm quite sure that those who watch this session would actually be getting enriched by watching this session. And thank you, Mr. Gopi, for accepting our invite. Over to you.
Yeah, thank you, Mr. Chatrat. It's a pleasure being on your show, which is well known in India and maybe abroad. Just to say that, this topic is something which is very dear to me because of the importance for the citizens of India. Now, the topic is public interest litigation, its evolution, development, and the law and the procedure involved in public interest litigation. Now, just to begin, in October 1975, to tell you that there was no public interest litigation law existing in India. But in October 1975, Justice Jayantilal Gandhi of the Bombay High Court gave a verdict of 953 pages. The case was, as you may remember, Bombay, as it was then called, is a city made up of 7 islands, and most of the land is reclaimed land. And one such portion in the south of India, which is called Back Bay Reclamation, and today which houses the Nariman Point, which houses, the Air India building, the Indian Express building, most of the banks are built on this particular land. So one parliamentarian, Mr. Pilu Modi, who was a Swatantra Party member in the parliament, and Ms. Mrinal Gore, who was a socialist MLA of the Maharashtra Legislative Assembly, filed a petition in the Mumbai High Court saying that, the process involved in giving out the land to these people are illegal, arbitrary, and capricious, and some corruption is involved. At that time, the Chief Minister of Maharashtra was VP Naik, and 2 other ministers were involved in that. One was Rafiq Zakaria. So the case was filed, the notice was sent to the government. The government pleaded that these 2 people have no locus standi because this is the government thing and they do not have it. Justice Gandhi heard them and said, no, they have an interest as long as... I'll read out a portion. Unfortunately, this judgment is not reported. It's almost 50 years ago. The government sought dismissal of the petition, arguing that the petitioners lacked a legal standing, a locus standi. The allotment was contractual and beyond judicial review. Justice Gandhi upheld the standing of the petitioners, where he said the disposal of government property was arbitrary and capricious, and important constitutional questions are involved. No injustice can be tolerated, and a technical plea of locus standi will not arise in the way of the court exercising its jurisdiction under Article 226 of the Constitution of India. Surprisingly, the government accepted this verdict They did not file an appeal with the Supreme Court, and thus was the first case where the Bombay High Court decided in favor of the petitioner and said that they have a locus standi. And they said that judicial intervention in government action or administrative authorities, the court can interfere if they find it arbitrary, malicious, malafide, or unjust. Over the period of time, with this case, the High Court expanded the oversight of its own turf. It declared valuable principles for governance and issued remedial action. I just want to tell you that PIL is not adversarial as we have it in criminal or civil litigation. It is a question of the court trying to bring the citizen, the state, and the court to resolve certain issues which are affecting the citizens of India. Now, after this, we had the emergency. This was in October 1975, just immediately after the emergency declared in June 26th of 1975. That period between 75, 77, we had various judgments, the most famous being the ADM Jabalpur, where the court, the Supreme Court, and the judges bowed down to the government and declared that during an emergency, there can be no habeas corpus and your freedom can be taken away. That was one of the darkest periods of Indian judiciary. But after the emergency was lifted, the courts started applying the principle. With PIL, the court shifted from being a mere constitutional appellate court to an institution of governance. Earlier, you had the courts looking at appellate petitions and constitutional matters. But now they started looking at the issue of governance, how the citizens are affected, how the government and the bureaucrats, act, whether they act in favor of the citizens. One of the reasons why, the court started taking interest in allowing PILs is the widespread human rights abuses which happened during the emergency, where hundreds, if not thousands of people were jailed without recourse to the courts. Government action that harmed public administration. And the other reason was the environmental disaster, environmental destruction of the environment and the habitats, the forests, the lakes, the rivers. So all this made the Supreme Court and the High Courts look into this matter. PIL has now become a choice, a vehicle of choice for the citizens to address their grievances. Today, in 2020, 70,000 PILs were filed in the Supreme Court. You can imagine, the distress of the citizens to go 70,000 already with the appeals, SLPs, and the writ petitions filed in the Supreme Court. An addition of 70,000 PILs are coming. In addition to that, the court also takes suo motu cognizance of matters. If there is a report in the newspaper And if the courts feel that, look, there is some injustice being done, they take it on their own. So last year, about 10 to 12 suo motu applications were taken by the courts themselves. Now, the PILs can be filed in the Supreme Court under Article 32 of our Constitution and Article 226 in the High Court. It is to be noted that PIL is only related to public grievances. I will in the end come to what topics, because over the period of time, a lot of people were filing PILs which were not actually public grievances. So the Supreme Court has given direction as to what can constitute in public as public grievances. So there is a list. So in the end, I'll let you know, what that lists are, and outside of that, it is very difficult for you to be entertained by the Supreme Court or the High Court. Now, in one of the decisions, the Supreme Court has defined PIL, I'll just read it out, as a cooperative or collaborative effort on the part of the petitioner, the state, and or public authorities and the courts to secure observance of the constitutional or legal rights, benefits, and privileges conferred upon the vulnerable sections of community, and to reach social justice to them. Social justice became a very important part, especially the Dalits and the Adivasis, whose rights were tampered with. Especially the Adivasis, they used to lose their land because of mining of iron ore and coal, especially in the states of Chhattisgarh, Jharkhand, and Odisha. So a lot of litigations were there when they were thrown out. We know about the Narmada dam case where lakhs of people, so there was a PIL petition on that. Now, one very important, I have given Mr. Chatrat a list of citations. I will only read out the petitioner and the respondents' names, but the citation in the SCC is available with him, so you can look at it. One is the People's Union for Democratic Rights versus the Union of India. It's a 1982 case. Now, some of the aspects of PIL is not adversarial, like in our normal cases, in the courts, where, it is adversarial. But this is not, both the petitioner, the respondent, and the court will try to come to a solution. I'll tell you, what happens later, in some critical technical cases, the Supreme Court will appoint a committee or amicus curiae to help the court in arriving at the right decision. So it is not adversarial. Even the petitioner will help him, because the petitioner comes to the court with a lot of data. Now that has to be vetted, verified, and seen if there is destruction or some inconvenience caused to the citizen. So that is what they try to do. So it is not adversarial. So all three parties will try to cooperate. Now, the orientation of the case is prospective. It is not retrospective. It will not, it has nothing to do with the past. It is only in the future what will happen after the case is decided. And as I mentioned, it is a problem-solving exercise. You got to solve it, because lakhs and millions of citizens are affected by a certain thing. For example, a dam, or Kudamkalam power plant, in South India. And the other thing is, lashes and delays are not, in certain things there is a limitation. If you delay in applying for something, the normal civil matters, it is likely that your case will be dismissed or you fail to get proper orders from the court. In this case, no lashes or delays are applicable. It is different from individual rights. There is no laws of limitation. So you can approach the court at any time at your time. But mostly, they are so critical that, you'll find people approaching the courts immediately. In general, in civil and criminal matters, the judges are very, very passive. They are an umpire, they weigh the pros and cons, the facts and the law, and which is normally associated with judicial functions. But here in PIL, the courts take an activist part. They can ask you probing questions. They can ask you, a lot of people, they tried in order to arrive at this. Because there are no laws governing what is happening around, it is basically trying to find a solution to the inconveniences or the factors affecting the citizens of India. Okay, now the thinking of PIL has been there, but the courts did not find enough in the constitution to help this. There are many well-meaning judges, but they were constrained by the constitution. But in America, most of you lawyers who have studied constitutional law will know about the Brown versus Board of Education. When I studied constitutional law, that was one of the big famous cases where Earl Warren, the Chief Justice, when he came to the court in, I think, 1954, he changed the court's outlook from being a conservative, though he himself was a conservative Republican vice president candidate, but he lost. But he was a Republican. But when he came to the court, he realized, the problems of the citizen. And Brown versus Board of Education was where he declared racial segregation in schools invalid. And that changed the whole gamut, and it integrated the blacks and the whites in the US. The second thing he did was in New York Times versus Sullivan. I have given the reference, the American reference in the citation. New York Times versus Sullivan, which was regarding to the freedom of press. It has elaborated, and this judgment has been followed by Indian courts with regard to freedom of press. And finally, it was Roe versus Wade. It's the abortion case. Of course, unfortunately, the Roe versus Wade has been diluted in a judgment by the current U.S. Supreme Court in June of 22. It has been diluted, but it is still there, where the rights have been given to the states to decide, not the center to decide. So that's a thing. Now, what contributed to PIL? It was the expanding role of the government, where the bureaucracy was involved, the local administration was involved. There was very little, supervision. So the local people, and as you go higher and higher, they were trying to, there are a lot of gaps where, people would get affected. The most important thing happened after Maneka Gandhi, the case. If you remember, we are all lawyers here. The Indian Constitution has saying that you can't life and liberty other than by procedure established by law. This was taken, when Benegal Rao and Dr. Ambedkar were framing they wanted to introduce due process in the constitution, but after Mr. Rao met Felix Frankfurter of the US Supreme Court, Felix Frankfurter told Rao, don't make the mistake, because most of the cases which come to the US Supreme Court is on due process, and it is very difficult to define what is due process, because nothing is defined. So it depends upon individual judges, or in the US Supreme Court, all the 9 judges decide. So it's very difficult. So he was very what is called, did not want to include it. But in the Japanese constitution, this procedure established by law was there. And incidentally, the Japanese constitution of 1945 was framed by the Americans themselves. General Douglas MacArthur, who was then heading the occupational forces in Japan, got some Americans to write the Constitution of Japan. In the Constitution, they avoided the due process because they knew what the problems were, and so they used the word procedure established by law, and that was taken in the Indian Constitution. That has been diluted in Maneka Gandhi, and almost in India, it is now due process. And after this, you'll find a series of decisions by the Indian Supreme Court, which, the procedure established by law is diluted. And with this, the whole thing started happening. With Maneka, the judiciary was empowered to supervise and invalidate any union or state action if found arbitrary, capricious, malefic. Just to explain, in 1950, our constitution was established on 26th of January 1950. On 27th of February 1950, Mr. A.K. Gopalan, a foremost communist leader of the then United Communist Party of India, was jailed under the Defense of India rules. And this case came up, which is A.K. Gopalan versus the state of Madras, where our Supreme Court, the judges in the Supreme Court, took a narrow view of Article 21. And they said that, the states imposing upon a person's life or personal liberty, and the state's action could not be challenged as violating fundamental rights. This was a big setback to fundamental rights. No doubt, the Constitution was new, and it took time for people to, the judges to look at it. And then there was the Indira Nehru Gandhi case versus Radnarayan in 1975. And this was just before the emergency. But the decision in Maneka Gandhi reversed this approach, this narrow approach, textual approach, as they call it, the textual approach, and redefined everything. This, the earlier courts, the judges were looking at in silos. For example, Article 14 in one silo, Article 19 in one silo, Article 21 in one silo. But in the Maneka Gandhi case, the court said that all these three, 14, 19, and 21, are not mutually exclusive and are interdependent and have to be looked in a composite manner. So, because of this, the court started to supervise and invalidate any union or state action, whether legislative or executive or any public authority perceived by the court to be arbitrary or unreasonable. Now, after Maneka Gandhi, a spate of judgments came. One was, Ramannath Dayaram Shetty versus International Airport Authorities of India, 1978. Then Kasturi Lal Lakshmi Reddy was the state of Jammu and Kashmir. I'll tell you what these cases are. And Ajay Hasia versus Khalid Mujib, 1981. The gist of the decisions were that government action was required to be based on some rational and relevant principles that was non-discriminatory, following which action would be treated as arbitrary and violative of Article 14 of the Constitution of India. This is the bedrock of this law. This is the bedrock of the administrative law doctrine, which forms the thing about EIL. Further, over the period of years, the Supreme Court expanded the meaning of the context. Article 21 to include every aspect of life that enabled a person to live with dignity. The SC also recognized the several unarticulated liberties. If you look at Article 19 and 21, there are some, there are about 10 liberties which are articulated, but there are some unarticulated freedoms and liberties that are implied. The Article 21 and 19 and 14 are explicit. But here, the Supreme Court is looking into things and saying that they are implied. Okay, so they try to justify this by looking at the directive principles of state policy, which is Chapter 4 of our Constitution. Chapter 4 is can't be enforced, like the fundamental rights. But though they are unenforceable, as per Article 37, it was increasingly cited as complementary to the fundamental rights and a justification for lending context and depth. Lending context and depth to the fundamental right to life. Now, as I said, Maneka Gandhi case, she had applied for a passport, it was denied, no system of natural justice was followed, no notice given, no inquiry held, and they just cancelled her passport. But the courts came back and said every Indian citizen has a right to travel, and that to travel abroad. In A.K. Gopalan, they said that our fundamental rights in Article 19 to travel anywhere in India was not applicable to a detainee. So that has been overruled. Then Hussaina Era Khatun was his Home Secretary, state of Bihar. They said right to speedy trial. In Bihar, there were 80 prisoners who were incarcerated and were in jail beyond their jail time, which would have otherwise been if they were convicted under IPC. So the court then looked into that matter and found that there were 80,000 under trial prisoners who have never been taken to court, and they are past their sentence period. Normally, you have to secure bail even if you don't get bail and you have finished one half of your sentence, then you are released. But here, the government did not bother, nobody bothered. Because of this case, all the prisoners were released, and the concept of right to speedy trial was there. Then Khatri versus State of Bihar, 1981, the right to legal aid, that was established. And then the legal aid thing when the high courts and all that was established. Then Chameli Singh versus State of UP, the right to shelter. So that is another. The funny thing, if you see, is that, all these were established before the year 2000. The greatest period of, PIL where many rights were included, and that has become the law today. That Olga Tellis in Bombay, the city where I come from, is, there were a lot of hutman dwellers on the pavements of Bombay, and they were evicted. And Olga Tellis was a reporter with one of the newspapers of India, and she had filed against the eviction order. And the Supreme Court then said that they can't be evicted and they have a right to a livelihood. Because if these people are evicted, then, where do they go? Where do they stay? Where do they work? So that, and then the concept of right to livelihood and a roof over your head came up. And then in Mohini Jain versus State of Karnataka, you have the right to education. That has established. Of course, subsequently, we amended the constitution to include up to the age of 14. And Dinesh Trivedi versus the Union of India, the right to know. Then the RTI Act and all came in. So wherever it has not been codified, the Supreme Court judgment will stay put. The third factor was, the legal aid to enable the poor and the disadvantaged to enforce their constitutional rights. As I said, this started after the emergency, which was the very sad period. As I said, as you may ask, why is, there is a separation of power between the judiciary, the executive, and the legislature. But then why, if there are some acts which are passed by the legislator or there are some executive orders, why is the court looking into this matter? Strictly speaking, the courts are not looking at whether the executive has the power to do it or the legislature has the power to legislate that particular act. It is only looking at whether it is arbitrary, it is malafide or capricious. It doesn't look at things. The evolution of PIL in the Supreme Court was, there are three phases that I think. One is the first phase is the SC, the Supreme Court issued directions to protect the right to life for the benefit of the marginalized groups who were denied access because of their poverty, illiteracy, and ignorance. That was the first phase. The second phase was the protection. If you see the case laws, you will see the first phase was on, rights of citizens with regard to the marginalized and the disadvantaged people. The second phase of the Supreme Court was paying attention to the environment, the forests, natural resources, and cultural heritage. which means that the non-destruction of certain areas which have a historical background, because land is scarce, especially in Delhi and other things, people want to take over the land and destroy some heritage buildings. But that was banned. And finally, they shifted from all this to inquire into the probity and transparency and integrity of the governance, whether the action taken was, transparent and there was no corruption, there was a necessity to do it, then, it would have been okay. But if otherwise, if it is, so the court is concerned with the process of the decision. The court does not ask whether it was right on the part of the executive or the legislature to pass a law or execute a law. It should not be capricious, malafide, arbitrary. The court believes that the executive can execute the laws and the legislature can pass laws. Now, the very important thing is standing, locus standi. Who has locus standi to file a PI? See, generally in normal law, procedural law, both criminal as well as civil, the person who is directly affected or injured has locus. Which is, we all as lawyers know about it. Because, if that principle was not there, then the courts would be burdened. I would file a case for my neighbor or a friend or whatever it is. But today, the procedural laws are very clear, so there's no confusion. But it is not the case in PI. The traditional view of locus standi prevents people to file a case without a locus standi or standing to approach the court with regard to matters. But for PIL, the law is different. For PIL, the enhancement of justice in respect of public grievances or with regard to the poor or disadvantaged, the court has taken a very liberal view. In Mumbai, Kamgar Sabha versus Abdul Bhai Fazul Bhai, the Supreme Court, in its order, in its judgment, has relaxed the traditional rule for governing locus standi. Because a court will not hear a party unless he or she has a substantial stake in the issue. Judicial perception of a person who has sufficient interest is critical. That is the law for our normal cases. But in case of PIL, this has been diluted, it has been relaxed. The Supreme Court has enlarged the concept of aggrieved. Who is an aggrieved person? Traditionally, only a person whose own right was in jeopardy was entitled to seek a remedy. But when extended to public action, a person asserting a public right or interest had to show special circumstances. Now, there are three types of standing which the Supreme Court has accepted. And one is the representative standing. It helps the poor. You have NGOs and a lot of associations which help, tribal association, workers association, so they can approach. That is the representative standing. For example, in the bonded labor case, Bandhua Mukti Morcha versus Union of India, there were a lot of bonded laborers, who had taken a few rupees from somebody, and then he was for his lifetime, and his children and their grandchildren would have to work to repay. So those who represent them, the volunteers who represent them, are described as representative standing, having representative standing. There was some organization which fought for pension for retired employees long ago, 1983. It is DS Naksara versus the Union of India. And improving living conditions for inmates in women rescue homes. This was filed by Upendra Bakshi and his organization. Upendra Bakshi, as you all know, is one of the greatest writers of constitutional law. And he was head of legal in Delhi University, I presume. So that case, looked into the living condition of rescued women in these rescue homes. Okay, now coming to us lawyers. The court has recognized the role of lawyers. I'll just read out what it recognized the standing of a public-spirited lawyer to move a petition on behalf of anyone who is aggrieved. In this case, as I mentioned to you about the Hussain Nara Khatun, it was raised by a lawyer in Bihar, where I told you that 18 prisoners were petitioned to be released, and then ultimately they found out that 80,000 prisoners are available. Just as lawyers, we have social activists who can petition the court. For example, the Narmada Bachao Andolan, which I mentioned, then the PUDR, People's Union for Democratic Rights. These are two cases where, social activities, Narmada Bachao Andolan, you had a lot of well-known women, Aruna Roy, a very famous lady, I forget her name. Medha Patkar was involved. Now, citizen standing. A concerned citizen or a voluntary organization may sue not representative of others, but in his own right as a member of citizenry. This, as I said, was, if you remember the first judge's case, the SP Gupta case. SP Gupta was not a lawyer or a judge or whatever it is. He had filed a case, and in that it was accepted. That case decided that the correct position of locus standi for a citizen. Even though SP Gupta filed the case, even though as a person, he has not suffered any individual harm because he is not a judge, but still he filed a case. So that was accepted, and that is the law today, that if you are a citizen, a concerned citizen, even if you are not affected by that particular thing, you can still file a case. So they have widened the whole thing to enable the right to justice to the entire citizenry. especially the poor and the poor, the depraved, and the disadvantaged. The only thing that the court will look at is whether you are a busybody. If you file 3-4 PIL in a month, then I'm sure the court will throw you out, because they will say you are a busybody. You have no other briefs, so you're just filing these briefs. So you must have heard of cases where somebody is fined 50,000 or a lakh for frivolous PILs, which usually happens, and they do it for publicity and other things. So we as lawyers have to be very careful. We have to study this, the case, and see if there is a real case. I will come to what is required at the end of your PIL petition. You're supposed to file an affidavit along with your petition, so that these petitions are not frivolous. They are not filed just for the heck of it. Now, coming to litigational competence. As I said, in 1981, the 7-judge bench delivered a definitive judgment in the S.P. Gupta case about competence. Though, the 7-judge bench in the S.P. Gupta case, they had delivered 7 separate judgments. But Justice Bhagwati, who pointed this out, about even if you don't have you are not affected directly with this, with that order or law, you can still file it as a concerned citizen. That was elaborated and proposition by Justice Bhagwati, and all the 7 judges agreed to that. So, it is a law today. Of course, S.P. Gupta was later overruled in the first judge's case. What you can derive from this is that, nowadays the judges lower the standing requirements. If it is a very serious case, it doesn't matter whether who is filing the case. If the nature of that problem or the injustice is very acute, the judges will take cognizance of that. That is the type of thing which is happening today. And if there are cases where a genuine case comes up, and maybe the petitioner is not able to argue, then the court will appoint an amicus curiae to advise or help the court to arrive at a decision. So that is also there. If they find that the petitioner is not competent to help, and if there is a genuine case, they will do it. The only thing the court insists is that there should be utmost good faith when you are filing a PIL. It is not for personal benefit or for publicity or to harm somebody else. If you have got a grudge against a local officer, you can't file. The court will see through that, and then you will be it will be dismissed, and maybe even a fine of lakh of rupees. So, as I said, where the bona fide of a petitioner is in doubt, but the cause of action is genuine and in the interest of the general public, the court may appoint an amicus curiae, keeping the original petitioner out. And usually the amicus curiae people do pro bono, and they are well-known senior lawyers in the Supreme Court, and they will do pro bono and do a good job and advise. I often I'm not able to recall any of those cases, but generally they have helped. Now, procedural innovations, what has happened, earlier, the strict rules of pleading don't apply to PI. You don't have to give a list of dates, synopsis, facts, statement of facts, reasons, prayer, not necessary. There is no particular format. But, over the period of time, because to make things easier, at least in my high court, there is a particular format which we follow. Maybe in other high courts and the Supreme Court, this is being followed. But generally, because the court will treat letters petition as a PI. I mean, there are cases where you write a letter from the jail, the court will accept it. It will, and they have laid down rules for the registry as to how to look at these letters petition. There's one case in a rural litigation entitlement versus state of UP, 1989, which was based on a letter petition. The other is D.K. Basu versus state of West Bengal. Most criminal lawyers will be aware of the famous decision in D.K. Basu. And this was a letter written by the chairman of the Legal Aid Services of West Bengal to the Supreme Court a letter and no formal PIL application or petition application. It was just a letter, it was taken up, and D.K. Basu laid down the guidelines as to how a prisoner is to be treated, how the police have to interact with them. So that laid down, and it is one of the bases of criminal law today. I mean, if you attend criminal cases, and if there is anything, you will find lawyers quoting D.K. Basu. And the judges in the trial court are very well aware of the. Sadly, the police are not aware, but the judges in the trial courts are very well aware. This thing, as you know, it is called epistolary jurisdiction, where a letter can be sent to a judge and he can take notice. So there are rules which are to be followed by the registry where you get letters petition. And as I said, so moto, where the Supreme Court or the High Court takes up matters on its own based on newspaper reports or media reports. Another thing, the PIL, once you file a PIL, you are not allowed to withdraw it. The other, in civil cases, you can petition to withdraw, but a PIL cannot be withdrawn. In Sheila Barsay versus Union of India, Sheila Barsay was a very famous activist and journalist. The Supreme Court in that judgment of 1989 said that you can't withdraw a PIL at your own sweet will. And so you can't withdraw a PIL once you file it. So be careful. So you got to go through it. Sometimes PILs or letter petitions are filed without adequate facts, or they are very sketchy. But there is a real problem. The Supreme Court will then ask for expert testimony. Say, for example, there is a dam coming up and that is going to displace a lot of people. Then, the Supreme Court will ask for an expert committee to be adopted, or for a government to be, government person to give a report on that, so that they can arrive at and see that no distress is caused to the people living in and around that place which is affected. Once the PIL is in your favor, then the you can report to the Supreme Court if any things are not followed, and they will be hauled up. For example, on pollution, a lot of companies pollute the rivers and the lakes, but after the judgment comes, you can always go back to them and get. Now, what are the main petitions that come? What are the subject matter? Is consumer rights, not your personal, not in the consumer redressal forum, but in general, consumer rights. Environmental, for example, the Taj Mahal in Agra was being polluted by the Mathura refinery. So a PIL was filed. And then the court gave certain guidelines as to how, after an elaborate search and, technical assessment, because they were saying that, the Taj Mahal marble was being, the color was changing. So that had happened. Urban planning, as I mentioned, the first case, October 1975, Jayantilal Gandhi, the Back Bay reclamation case, that was urban planning. Human rights, but the habeas corpus thing doesn't come under PI. That has to be a separate thing under Article 32. It will not be a part of PI. But if there is a collection of prisoners, then it is a PI. Instead of filing each individual habeas corpus, you can file a collective petition, but individual person will be a separate case under Article 32 of the Constitution. Animal rights. Now the Supreme Court is concerned with the dog issue, dogs biting boys in the street and all that. So that also is, how to get it organized. Child rights is another issue. And judicial accountability also. There is a judicial, extrajudicial killing. This happened in Bombay. The encounter specialists, now they are all in jail. So that the harassment of women in workplaces, that was filed as a PIL. Vishaka was the state of Rajasthan, which is the laid down law with regard to treatment of women in workplace. Vikasa is the leading law, and in any of the women in workplace, there is then you had pollution by industries, as I mentioned, the Tehri Bandh Virodhi Sangharsh Samiti, the Tehri lake was being polluted, so that also there is a ruling. Then there is another case in Tamil Nadu, Vellore, where there were 900 tanneries in Vellore, these leather tanneries, which were polluting the lakes and the underground water. So the Vellore Citizen Welfare Forum had filed a petition, and that was resolved. And I think certain steps have been taken to see that both parties, the tanneries and the citizens, are happy. So this is the way PIL works. It has got to be okay. This is all right. The courts are accepting a PIL, but there are cases where the courts have refused. They have refused to entertain PILs which say that it pertains to policy. As long as, it is a policy matter and it doesn't affect your rights or doesn't hurt you in any way, hurt your fundamental rights or any way, then you can't approach. Policy matter is for the administration to take place. So you have to be very careful, distinguish. Just somebody has a policy, you can't go to the Supreme Court. Is it hurting you? Is it hurting the general public? Then it is something that the court will entertain. So we have a lot of people who rush to the court when there is a policy frame. But as long as the policy is not affecting people, let's not go to the court. It will harm your case. Your name will be spoiled. Your name will come in the papers that this fellow's case is dismissed. So it's bad. The only thing is maybe the court will ask the government, this is the petition. It says all this. Are you aware that these will happen? If the government says, yes, it will happen, we are taking care of it, then the case is dismissed. So let us be very careful, when drafting, whether there's a real cause, whether people are affected, then only let us file the PI. Then, the 2G case, before that, the Delhi Science Forum had filed some 2G case and all that. The court said, this is a policy matter. It is nothing to do with, it is not affecting anybody. I think it was something about technology or something. So that was prohibition of liquor sales. If liquor is banned in something, it's a policy. I mean, is it hurting somebody? It doesn't hurt anybody. The ladies in the village and all are happy if the liquor is banned. And somebody filed a PIL for common civil code. I mean, it's not even there. I mean, if it is there and it is affected, then we will see later. But not just to. And then, the controversial Gyanvapi Masjid and Vishwanath Kashi temple, it was all dismissed. Okay, now coming to how people abuse the process. Okay, there's something which passing of individual interest as PI. And there are a lot of people who want to harass the local, administration. They will file. It's a petition to harass. The courts can make it out. Petition for media attention. Or to ventilate a personal grievance against a particular officer. It is hidden as an IPL, but I am really targeting somebody else. So we have to be very careful. Okay, the other thing is, the court nowadays generally asks is that whether you have exhausted all remedies available before coming to us. Like if there is a local problem with regard to urban planning or something like that, you have to appear or write to the local authorities, if not go to the higher. If your claims are rejected and they are not able to understand or they purposefully don't understand your case for many reasons, then you can go. They will ask you that whether you have done your research, whether you've gone to the proper authorities for redressal. If it doesn't happen, then you come. So, nowadays they're very careful. They will say, you first go there, then we will talk about it. So we have to be very careful before you file a PIL to see that, all the available hierarchy of grievance address is exhausted. And even if you are still dissatisfied, you can go and file a PIL. And as I said, last year 70,000 PILs were filed, and on an average 25,000. If you take the average from 1985 till now, it's an average of 25,000. But in the last few years, there has been a spike going up. So, okay, now I was telling you, the format of the PIL is almost the same as our other writ petitions, except that you have to file a affidavit in the end, which is subject matter in brief. What is the thing? Particulars about the petitioner. What is his background? What is whether you are an individual or an organization? This, and it is better to say that we are doing this and all that, and give a good idea to show that you are a genuine person, not interested in some publicity or media attention. Declaration and an undertaking that it is a public interest litigation, that the petitioner has no personal interest, and this is being filed in the interest of the general public. Please see that, because the courts can be harsh with you if they have a slight doubt about your intentions. And the expenses are being met by the petitioner. Don't say somebody else is financing this petition. Then that has a different intention. So you have to mention clearly that I am funding it. I am paying for all this. That the petitioners have done a thorough research in the matter and have exhausted all available remedies in the context. If the court is suspicious, it may ask you to furnish a deposit towards cost. You have to mention in the affidavit that if the court asks me to file a deposit, I will file the deposit. So you better put that. And if they find that this is something frivolous, you might, your deposit may go. So, basically, it is that. And I will just, this is a Supreme Court circular. I have the Karnataka High Court also, which lays down who can do that. I'll first read out what cannot come under PI. Okay. Now, what matters can come under PI? Bonded labor matters, neglected children, non-payment of minimum wages to workers and exploitation of casual workers, violation of labor laws, collective, not individual. The individual, you have to go to the labor courts, but collective, this. Petitions from jails complaining about harassment or for seeking release, having completed 14 years of jail and all that. And petitions against atrocities of women, harassment of brides. A petition complaining about harassment or torture of villagers by co-villagers or police from persons belonging to scheduled caste to scheduled tribes. Environmental pollution, we have disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, petitions from rape victims, family pension. So this is the thing what the Supreme Court has said. What is not allowed? Landlord-tenant disputes, service matters pertaining to pension, personal disputes between individuals, dispute relating to contractual or statutory liabilities, matrimonial disputes, seeking police protection, admission to educational institution, maintenance of wife, children, and parents, and early hearing of pending matters in high courts or in courts. So, Mr. Chatra, I am done with my talk, if there is any question, I'll be happy to take.
Thank you, Mr. Gopi. I think you have taken the platform across the different spectrums. And as you had suggested that you will take over the legal issues and different aspects. Somebody has asked for your mobile number, sir. You can just tap it.
If you can send, Mr. Chatrat has my email ID.
I will share him my mobile number.
Yeah, you can send it to me and I will.
Yeah, that's my mobile number. Doctor. So thank you for sharing your knowledge, sir. It was a session which had deep insights on the aspects of public interest litigation. I'm quite sure that not only students, lawyers, judges, and common man will learn from it. Thank you. And Dr. Damodaran, you can connect with me on my WhatsApp or a regular call. Thank you.
So we end this today.
Thank you.